Today we will be discussing about the appointment and declaration of guardians under Chapter 2 of the Guardians and Ward Act. Section 5 has been repealed. Section 5 is subject to repeal, whereas Section 6, in case if a minor is not a British European subject. Nothing in this act will take away the power to appoint the guardian for his person or property of both if it is valid by law. The court can appoint a guardian if it is satisfied that it is for the welfare of the minor, and an order will be made in that regard. The order will be made to appoint a guardian of his person, property, or both. It can be made for declaring a person to appointed to be a guardian, and a guardian can be removed if he has not been appointed by will or other instrument. However, if he has been appointed by will or other instrument, the person aforesaid will cease to be the guardian by declaring another person to be the guardian. This means that if the previous guardian will cease to exercise powers according to PLJ 2001 Islamabad 1110, mother cannot remove a minor to a place which is inaccessible to the father of the minor. Now the question arises, who are entitled to apply for the orders? Any person who is desirous of being his guardian. It could be any relative or friend of the minor. It could be the collector of the district within the local area where the minor resides. It could be the place where the minor has property. It could be the place where the collector has authority with respect to a specific class to which the minor belongs. If application with respect to guardianship of person is made, it will lie in the district court having jurisdiction where the minor ordinarily resides. In case of his property, it can lie in either where the place minor ordinarily resides or where the property of the minor is situated. If an application is made to a district court which does not have jurisdiction, then it may return the application to the court having jurisdiction. Section 10 deals with forms of application. If the application is not made by the collector, then it will be signed and verified in the manner provided in the Civil Procedure Code. Particulars in the form of application should contain the name of the minor, his sex, religion, date of birth, and his residence. If a minor is a female, then it is essential to state the name of her husband and his age. Then we move on to the nature of the property. If the minor has any property, then you have to state the place where it is situated, its approximate value. Then state the name and place of residence of any person who has the custody of minor, or who has his custody as well as the possession or custody of his property, or both, as the case may be. You need to make mention of what near relations the minor has and where they reside. Whether the guardian of his person or property of both is appointed by person to entitled by law to make the appointment of the guardian. You have to state to which court an application of guardianship of his person or property of both is made, when the application was made, to which court it was made, and what was the result of that application. Whether the application is for the appointment or declaration of the guardian of his person, property, or both. If an application has been made to appoint a guardian, then it is necessary to state his qualifications. Where the application is made to declare a guardian, then you have to mention the grounds on which the person claims to be a guardian. You need to mention the cause which have led to making the application. Other particulars which are necessary to state in the application. If application is made by the court, it shall be by letter addressed to the court and forwarded by post in a convenient manner. And all particulars are to be mentioned which I have previously discussed in the forms of application. The application must be accompanied by a declaration of the willingness of the proposed guardian to act as a guardian. That declaration must be signed by him and it must be attested by at least 2 witnesses. If the court is satisfied that there is ground for proceeding the application, it shall fix a day for hearing and cause a notice to be served. Notice will be served in a manner certain by the civil procedure courts. Notice will be served the parents of the minor if they are residing in Pakistan. It could be served on a person who is named in the petition or letter as having the custody or possession of the person property of the minor. It could be the person who is proposed in the application to be appointed a guardian or any other person whom the courts think fit that a special notice or application should be served to him.